Very good afternoon to all of you. This afternoon, I would like to announce to you that at 5:30 p.m., we have a special land law revision with His Lordship, Professor Sir Justice Dennis Ejay of the Court of Appeal. So he will be with us at 5:30. But from now to the next 1.5 hours or so, I propose to give you what I call the very final revision of contracts. So I'm doing what we call the A to Z recap. So I'd like you to pay rapt attention. So what I'm going to do is to use the first part to just walk you through to give you some kind of like a panoramic view, right, of what needs to be emphasized as far as contract is concerned. And once I am done, I will invite you, if you have some comments to make, or some additions or questions or whatever, then we do that. And then you end the session, and then we rest for about an hour and a half to welcome land law revision at 5:30 with the Sir Dennis. And a different link will be sent to you after this lecture. Now, so first of all, we have to remember that law of contract is a very important area of the common law. It's a very important area of the common law, and we know that it is that aspect of the common law which enables us to understand which promises are enforceable and which promises are not enforceable. So we have to remember that why do we enforce contracts? Contracts is enforced because of the underlying philosophy of what we call the freedom of contract, right? That the people who are of full age or recognized capacity in law have sat down and negotiated, and for that matter, the law says that what they have, for example, done should be given effect or should be upheld by the everyone. And for that matter, we talk about sanctity of contract, that the will which they have expressed is sacred and it should be upheld by all. So sanctity of contract, contract is supposed to be enforced, is supposed to be upheld. So we have what they call the pacta sunt servanda. Pacta sunt servanda. Now, having known this basic philosophy underlying why we enforce contracts, it is pertinent to remember that there are two types of contracts. We have what we call the simple contract and then formal contract, also known as specialty contract or contract under seal. So a contract under seal, as a matter of necessity, has to be in writing, as we have noted before. And because it has to be in writing, there's also the need for it to have the seal of the parties. So the party seal should be there. Once the seal of the parties are there, the contract can be enforced without a need for consideration provided. So that is the one thing that we have to note. So a contract under seal is a formal contract. It's also known as a specialty contract, a contract by deed. It has to be in writing, have the seal of the parties. Good. And what are examples of contracts which are supposed to be in writing, even where the seal of the parties are even not required as well? Of course, we have the contract of guarantee, as we saw under the Contract Act 1960 Act 25. Now, quite apart from formal contract, we also have what we call the Parol contracts, also known as the simple. That is a contract which does not have to be in writing. It doesn't mean that it cannot be in writing. It can be in writing. Writing is not a requirement. It can be in writing, but writing is not a requirement. For that matter, the position of the common law has been that such a contract is not enforceable unless it is supported by consideration. Unless it is supported by consideration. So that has been like the orthodox position of the common law. But we know very well that in Ghana, because of the Contract Act, 1960 Act 25, there has been some significant modification of the doctrine of consideration. So therefore, even some simple contracts can still be enforceable despite the fact that there is no consideration. I'll give you a typical example. You look at Section 8, subsection 1 of the Contract Act, 1960 Act 25, for example. It makes the point that a promise to keep an offer open for a stated period of time is not invalid due to absence of consideration, therefore. In other words, where you have promised someone that you are leaving an offer open for a defined period of time, even where the person has not provided consideration, our lawmakers, per Section 8, subsection 1 of 25, is saying that you must keep the offer for the said period. Yeah, so that is just a quick example of how simple contract may be enforceable without requirement of what? Consideration. So having known that, we have to ask ourselves, for simple contracts, what needs to be present before we can say that there's a contract? What are the elements of contract? To have a contract in place, first and foremost, we must have agreement. Agreement is evidenced by the presence of offer and acceptance. So let's keep that in mind. And apart from the agreement, evidence usually by offer and acceptance, the parties must also have intention to create legal relation. That is to say that what they are doing, they should do it in the sure knowledge or with the understanding that there will be legal consequences should there be a default, as it were. And again, the parties must also be qualified in law to enter into the transaction that they are doing. So we say that they must have capacity to contract. So that is another element of a valid contract. You must be qualified in law to enter into that transaction. And for this, remember the special categories of people who do not have like a full capacity and all that. We talk about it like briefly. And we also make the point that if the contract is a simple contract, then as a general rule, consideration must be provided before same will be enforceable. Otherwise, it's not enforceable, as we have seen. Of course, subject to the exception that we have under the Contract Act 1960 Act 25. And another element is that there should be certainty of terms. There should be clear understanding regarding what the duties or the obligation and rights of the parties are. So those are like the terms. So there should be certainty. And the other requirement is also that the parties must have given genuine consent. So genuineness of consent. And what that means is that the consent of the parties to the contract should not have been obtained as a result of any vitiating factor, maybe as a result of mistake, misrepresentation, duress, or influence. So the consent must be genuine. And because the consent must be genuine, that is what reinforces the principle of sanctity of contract, meaning that parties have freely and genuinely given their consent to contractual agreements, then same is binding and same must be respected by all. And contract must be pacta sunt servanda. And finally, another element is that the contract should satisfy legality. In other words, the contract should not be contrary to public policy, or it should not be illegal. So when these are present, then we have a valid and a binding contract in place. So let's keep that in mind. So first of all, we would like to come back and look at the various elements briefly, and we propose to do them possible within the shortest possible time. As we know, law of contract is learned over 2 semesters, but the ambitious project this afternoon is that for the sake of helping you to get a quick brush up for your examination on Tuesday, we are trying to use just about an hour or two to give you an insight out of what is usually done over 8 months. That is 2 semesters, 4 months, 4 months. So let's hope to do that. God is our helper. Good. So we'll go back to agreement. We said that to have an agreement, you must have offer and acceptance. That is a usual thing. But before you take each of these and look at it briefly and we move on, we have to answer the question, how do we determine the existence of agreement? Well, we have 2 tests in law. What do you call the objective test and then the subjective test? The objective test is the preferred dominant approach in trying to make a determination as whether the parties have actually agreed on something. What do you mean by the objective test? The objective test simply means that the court will look at the external manifestation. The court will look at the position of the official bystander. An official bystander is a disinterested, reasonable person assumed to be present when the parties made offer or when another party accepted the offer. So that, assuming at the time that the offer was made, a disinterested, reasonable person, disinterested in the sense that he didn't have his interest aligned to the offeror or the offeree, but he just a neutral observer. That's what we mean by the official bystander. Assuming he or she were to be present, what will he or she have understood the parties as having really agreed upon? Now, what he or she will have understood the parties as having agreed upon is what we mean by using the objective test, right, to determine the existence of the agreement. And for that matter, we often talk about consensus addendum, right? Consensus addendum. Consensus addendum simply means that the meeting of minds, that the mind of the 2 parties have met on something. Now, if you are going by consensus addendum simplicity, there is that presupposition that there is actual coincidence of what A is thinking and what B is thinking, what the offeror is thinking, and then what the offeree is thinking on the same thing. But in reality, it's not really like that. Because if that were to be the case, then you'll be doing the subjective test. But that is not the point. We use what a reasonable person would take the 2 parties as having agreed upon. So that will be how we establish that. And that was why in the cases that we know, Tamplin versus James, Smith and Hughes, Raffles and Wichelhurst, they are all indicative of how the objective test is used to determine what the parties have actually agreed upon, rather than what one party subjectively claimed to have been what was agreed. Let's keep that in mind. So having noted that, we will come back to what an offer is. An offer, we understand it to simply be an indication of willingness on the part of one party, the offeror or the promisor, to enter into contract with another party called the offeree or the promisee. So it is a proposal. So it's a proposal which has got element of finality. So if you look at the case NTAC versus entry, Justice Ateba quite emphatic that what is called an offer must have that crucial element of finality. The element of finality means that no room for further negotiation. The maker of the offer or the offeror is saying that I am ready to be committed, I am ready to be bound, if the other party will accept what I have put on the table. So that is what we should keep in mind. And for that matter, we need to distinguish an offer from what we call invitation to treat. Invitation to treat does not have element of finality. It's simply calling upon other party, evincing an intention to the other party that he should come forward and make an offer and make a proposal, which you may accept or reject. So that is invitation to treat. And for that matter, a number of cases in which the court have said that certain things, which on the face of it offer is not really an offer, but it's an invitation to treat. Example, display of goods in self-service shop or in the window of a shop. As we saw in the Fisher and Bell, Pharmaceutical Society of Great Britain and all that. All these are invitation to treat. Okay. And then where you have an advertisement, we need to draw a distinction as whether advertisement is an invitation to treat or an offer is very much dependent upon whether we are talking about potentially bilateral contracts or we are talking about bilateral contract. What do you mean by bilateral contract? Bilateral contracts, as we remember, of course, all of us have gone through LLB. And as I've told you, I don't pretend to be giving a lecture. How we call a crash final revision. So that is why I'm talking very fast. And so unilateral contract simply means that there's a request for a particular action in return for a promise of payment. So that is a unilateral offer. One party has made a promise requiring something to be done, and once that thing, a certain payment or a certain reward is provided. So we have only one promise. The other party who is interested is just supposed to act. Is back. So that is what you say. You say unilateral. Unilateral means that one, but the one has to do with a promise. There's a promise by one person, the promisor, requiring the promisee to perform an act, as we saw in cases of like the Kabbalah smoke ball, right? Carl again, Kabbalah smoke ball. That was an invitation to treat the advertisement of the smoke ball, use it as then get the stated side effect, influenza. Then you are entitled to the promised reward of the £100. And then they said that to demonstrate the sincerity, intention, they had deposited some funds with their bank and over on. So that is what they call the contract and not an invitation to treat. Or you look like R and Clark, Williams and Cowarden, Fitch and Sinedeker, or Gibbons and Proctor. All these cases, the examples of bilateral contract because there was a request for a particular act, either provide information or do something. Then we will give you a reward, your payment. So let's keep that in mind. And then bilateral contract, on the other hand, bilateral, and the two here is in relation to two promises. One party has made a promise, and the other party has also made a promise in response or in return for that promise. So promise for promise is the element of like the bargain, and that is bilateral contract. So the offeror promise to give a table, right, in return for maybe 10. The offeree has also promised to pay 10 cedis in return for a table. So a promise for a promise. So that is bilateral. And that one will require acceptance, not just by doing, but actually accepting, giving an assent, giving an approval contained in the proposal. So let's keep that in mind. So I appreciated that as whether an offer or invitation to treat will depend very much upon whether we are talking about unilateral contract or bilateral contract. The position of the law is that it will ultimately depend upon the wording of that advertisement. If you analyze the wording of the advertisement and suppose that it contains the element of finality, the fact that just like we saw in the Carl and Kabbalah, the company did not expect Mrs. Carly to come and tell them that, please keep the reward for me. I'm going to buy that and I'm going to use it as you have said. And I can't, no. All that was required was that go ahead, buy it as indicated, and then get the stated the outcome. Yeah. But if you take cases like the Patrick and all that, the Brambling Fish, Hen and Coke and all that, notice that we did not have that element of finality. So that was actually saying that come forward, make a proposal, we may accept or reject, or come for negotiation. Is the invitation to trade. So the takeaway is advertisement may be invitation to trade, or it may not be invitation to trade, but an offer. Whether what is contained in the advertisement can be interpreted as requiring a particular act to be done in return for a promise, reward, or payment, so then it is an offer, because in that case, you are gravitating towards the category of unilateral. On the other hand, where it is not asking for that, but it's saying that, yes, come forward, it appears, you interpret it, it means that come forward and make a proposal which you accept or reject. That is an invitation to trade. So let's keep that in mind. And again, the authorities have also held that when it comes to auction, right? When it comes to auction, there's a call for bid, and that is considered as an invitation to trade. You are making the offer, and then the auctioneer will indicate its acceptance or otherwise by knocking down. Let's keep that in mind. Now, so that is enough for now as far as the distinction between offer and invitation to trade is concerned. And we would like to talk briefly about the issue of offer. Offer may be terminated. So what are some of the ways to be terminated or may cease to exist? So first, an offer can be terminated by withdrawal, right? Or revocation. If you made an offer and then you have withdrawn it or revoke it, the offer is not there. So let's keep that in. When it comes to unilateral contracts, then the position of the law is that once the other party has embarked upon the performance of the Promise Act, as in the case of Errington and Errington, then you cannot revoke the offer. That is a unilateral offer, unilateral contract, as it were. But in the case of potential bank, where the other party performs the offer, and where there's no particular time stipulated, the offer can be revoked or withdrawn at any time. However, according to Section 8, subsection 1 of the Contract Act 1925, where there's a timeline, right, on the offer so made, then you do not have the freedom to withdraw it as and when you want. You have to wait for the time which has been prescribed to actually lapse before you can withdraw it. And it does not matter that the other party has actually not provided consideration by buying the option for you to keep the offer open for the said period. Our law says that if you said that you are keeping the bicycle for 1 week, you are bound to keep it for 1 week, even if the other party has not actually provided commitment. Let's keep that in mind. An offer may be terminated. Counter offer simply means that the offeree, instead of accepting the offer made, makes another offer, which is a rejection of the original offer, and that is counter offer. Remember the case of height and range, right? The offer was 1,000, then they made the counter offer at 9, and the court said that the second offer was the original offer. So let's keep. Then, quite apart from counter offer, it will be terminated by failure of the conditions. Remember the case of Financing and Stimson. If an offer was made and the offer was premised or predicated upon a particular condition, so that for the offer to remain in force, that condition is supposed to remain as it was. What that means is that should the particular condition or the particular event upon which the offer was predicated cease to be there, then the offer will be said to have also lapsed or will serve to have actually been terminated. So failure of conditions subject to, and again, death may also be an offer may be terminated, especially where what was offered has to do with like personal service. For personal service, if the person dies, then the offer will have terminated. On the other hand, if it has to do with maybe like land or other things, which can survive the maker of the offer, then depending upon the circumstances, death per se may not necessarily bring about the so let's keep that in mind. So that is enough for offer because of the time against which we are making this fast race to try to finish our revision of law of contract. So this will bring us to acceptance. We have to understand two things about acceptance. We have to understand what constitutes an acceptance, the fact of acceptance, and then what we call communication of what? Acceptance. These are the two things which need to be kept in mind. So first, acceptance, what is it? The fact of acceptance. Acceptance can be explained in any ways, but the magical understanding or the magical phrases of acceptance refers to approval or assent or endorse the proposal contained in the offer without any qualification or without any condition, or an acceptance is unqualified or unconditional approval of the proposal in the offer, right? So the information, however you want to use your words to catch an acceptance, is that I think you have to, the acceptance means you are containing the offer. And secondly, conditional approval. It is unconditional approval. It is unequivocal. You accept it without any equivocation, without any. But that notwithstanding, this says that yes, if you introduce new term in trying to accept it, that is a counter offer, as we've seen not long ago, by the original offer. But there's a room for you to make a genuine inquiry to try and find out whether the offeror will be amenable or something like that, instrumental payment and so on. Generally asking for information about the offer is not tantamount to making a new offer, for which reason it will be counter offer, destroying the original offer. So you contrast the case of a hide and rent with the case of Stevens and Macronas. Remember, okay, and then the DB and the Nsia and all that. Okay, so let's keep that in mind. Now we also have to remember that the acceptance can be by word of mouth, or it may be by conduct, or maybe in writing. So we can accept conduct of the parties. So sometimes an offer has been made. The other party may not openly write to say that I've accepted it, but his or her subsequent conduct will show that he has accepted that which was actually contained in the offer. It doesn't matter that for example, he was supposed to have signed. He has not signed it, and yet, if it, which suggests that he has actually accepted that offer, that could be construed as what? Acceptance. So let's keep that in mind. And we must also have in mind the communication of acceptance, right? Acceptance is not effective. Acceptance is not valid unless it is made known to the maker of the offer, the offeree. If the offeror or the promisor is not aware that you have accepted, is no acceptance. So therefore, acceptance must be communicated. Acceptance must be communicated. That is the general rule. If acceptance is not communicated, it is not effective, it is not valid. That is the general rule. On the other hand, we also have what you call like the postal rule. The postal rule of communication simply says that where you are using the mode of posting to communicate the acceptance, then so long as you have properly addressed the acceptance and then you have posted it in the usual way of posting. I mean, within the established practice of posting within the particular area in order. Acceptance is from the moment that you posted, and not, please, if you have questions, I like, what I'm doing now is you have uninterrupted living. Then when I say full stop, then I'll take all the questions, all right? Thank you very much. Yes, so we can put the questions down. When I'm done, I will take the questions. Otherwise, I will not be able to finish what I want to do. I am personally not leading you in revision of a law of contract until Tuesday. I have one or two colleagues who have promised to come. That's one or two questions, but in terms of the general review of the principle. Okay, thank you. Yeah, so just before that, I think I was rule. My line is breaking. No, but from my end, my line is not breaking. So sorry about that. But I'm recording the session. So if it appears that where you are not play it back. But I don't get any indication from my end that my line. Maybe let me bring my machine a bit closer. Maybe that may improve. Yeah, so about Postal, once you have posted the letter containing the acceptance in the usual way and all that, then acceptance from the moment that you posted the letter gets to the Parol. So let's keep that in mind. So that is the rule. Remember the case of Adams and Linsell and all that. So, but quite rule, I mean, with respect to rule, we also have exceptions. So one exception is that the offeror can actually opt out of the postal rule and says that he would like the acceptance to actually reach him, right? He would like the acceptance to actually reach him, and not until the acceptance you are not deemed to have actually accepted. So let's keep that in mind. So it's not all the case that the postal rule of acceptance is automatically applicable. The offeror can say that he would like the acceptance to reach him. And remember the case of Howell Securities Limited against Hughes. Howell Securities Limited against Hughes. If you remember, the offer said that if the offeree was interested in exercising the option, right, to buy the property, then he should indicate it in writing. And then the court said that because the offeror had indicated that if the offeree was interested in exercising the option to purchase, it should be in writing. Now, the writing meant that the offeror had actually opted out of the postal rule, because if the document does not reach him or her, how could he? So it's possible for the offeror in presenting the offer to indicate from how it is worded. So let's keep that in mind. And I mentioned Howell Securities Limited against what? Against use. Now, quite apart from that, instantaneous, another exception to the postal rule, where the mode of communication between the offeror and the offeree is instantaneous, maybe like the telephone, maybe like telephone and all that. What that means is that as soon as I speak, the law, as reflected in the case of Entos Malfa East Corporation, right? Entos again Malfa East Corporation case, that in the case of instantaneous mode of communication, acceptance takes place only when it has actually reached the offeror, meaning that if we speak and the offeror, you have not accepted because the postal rule does not apply. And of course, we also have to remember what we call the Electronic Transactions Act of Ghana. The Electronic Transaction Act of Ghana is very important. I'm referring to Act 772. That where you are using electronic means, then once the example leaves the information retrieval system or the information system, leaves a system that you don't have control over, actually accepted, even if it has not gotten to the other side, because it has left which you have a control. So let's keep that in mind. So it is also possible overall to present as a mode of communication. So the overall could, no, I mean, sorry. The overall, sorry. Silence as a mode of communication. There has been an understanding between the offeror and the offeree that in the course of negotiation said, okay, I'm giving you this time to think about if by Monday I don't hear from you, should I take it that you have accepted the offer as made? Now, that one, there's that kind of like a mutual understanding between the parties, and that comes a very legitimate mode of communicating acceptance. However, what the law frowns upon, and as you know very well, the case of Feldhaus, Parol cannot unilaterally, that is by himself or herself alone, impose offeree as a mode of communication of acceptance, so that it does not lie in the power of the offeror to say that, just as we saw in the Feldhaus and Bindley, that I'm selling, like I'm buying the horse for this. If I don't hear from you, no. So that one is unilateral imposition of silence on the offeree. That one is frowned upon by the law. Filters against that in mind. Now, this will mark end of discussion of acceptance, and we will move on to create a legal relation is an element or aspect of formation of contract which enable which are legally enforceable and which promises are not legally. Because a number of you are complaining that the line is breaking, I'm probably going to lock the class so that. Do you agree that? Should I lock the meeting so that nobody can come in again? I should lock it. Okay. Okay, then I'm going to lock it. We have 180, but we still have maybe let's okay, but once I lock it, then they cannot join again. So once I've locked it, if you leave, you cannot come back again, okay? You just have to go back and then play, but I've locked the meeting now. Okay, good. Yeah, so I was talking about intention to create legal relation, and I was making the point that it enables us to draw a line between promises which are legally enforceable and promises which are not legally enforceable. So that is the first point to note about that purpose. Contracts or promises are put into two big categories. One category, what we call the social and domestic contract, and then another category, what we call like the commercial contract or commercial agreements. Now, with respect to social and domestic contract, the law states a general principle, what we call a presumption, that there is no intention to create legal relation. That is to say that if the particular promise that we are talking about can be classified as social and domestic agreement, as a general rule, we don't intend that it was meant between spouses, wife and husband, parent and a child, and sometimes those in a close living in a household and all that. All those are examples. Remember the case of Bafo and Bafo. And then, but we have exception where it is clear that despite the fact that the contract can be classified as, and the intention of the parties was quite clear that they wanted it to be legally enforceable. Then, as the court have said, if they examine the whole thing, the intention is so clear. That's a thing. They want it to be legally enforceable, so will be it. Then the presumption, which will say that there's no intention to create legal relation, will have been rebutted, and then the court will say that there was an intention to create legal relation. For example, what's happened in the case like the merit and merit, you know, because the marriage was estranged, and not only that, even sometimes let's emphasize that don't let us get this wrong conception. Husband and wife, then it's domestic and social law. In my view, from closer analysis of the authorities, is that it will depend upon the actual circumstance. So just being a husband and wife or being a parent and a child is only a presumption, what do you call a rebuttable presumption, right? It raises a rebuttable presumption or prima facie a case that there's no intention to create a legal relation. But if you can examine the circumstances and you have evidence to show that, yes, despite the fact that husband and wife, parent and child, social and domestic agreement, and yet they wanted it to be legally enforceable, that will be legally enforceable. So let's keep that in mind. On the other hand, when it comes to commercial agreements, the reverse is the case. Commercial agreements, as we said, that when it comes to business, there's no room for jokes. Business means business. So the law says that in commercial agreements, the starting position is that there is intention to create legal relation. Are meant to actually enforceable. Yeah, I have switched off the sound, so I think the sound will not come again. It's meant to lead to legally enforceable obligation, as it were. But that is also rebuttable, meaning that there are situations in which you can say that despite the fact that it's commercial agreement, we do not want it to be binding. Remember the case of Frank and Crompton brothers, the famous, what they call the honor clause, honorable pledge clause. You have all agreements, and then you put in a clause that you do not intend it to be legally binding, but it's only meant to be binding only in honor. Or you can even cite the case of Edel Brand against Heller and Partners, where the profession, having given the opinion and everything, they put in a disclaimer that we do not accept what liability. So disclaimer, honorable pledge clause are all indications that within commercial agreement, you can actually negative, or you can actually negate the intention to create what? Legal relation. So let's keep that in mind. But as I'm leaving intention to create legal relation, my advice is that it ultimately depends upon the actual circumstances of the transaction that you have on hand. The presumption that we have mentioned, that's why we say that they're rebuttable presumption. They are just general conclusion, but that is not to say that you can never get a situation where, let's say that domestic and social agreement, we say that there's intention to create legal relation. You can really get that depending upon the circumstances. And then in quite the same vein, you could also get commercial agreement where, despite the fact that it's a serious commercial setup, commercial setting and all that, there was no intention to create legal relations. So please, let's keep that in mind. Now, this will bring us to capacity to contract. By capacity to contract, we are referring to who qualifies to enter into contract. Is it every Tom, Dick, and Harry who can enter into the contract? The answer is no. Now, the starting position of the law is that every adult, right, or every person of full age, that is adult age, and of sound mind, compos mentis, is qualified to enter into any contract permitted by law. So you can exercise freedom of contract so long as it's not against law, it's not against public policy. So that is one thing that you should keep in mind. However, we have some individuals, right, some category of persons that the law takes the view that they do not have full capacity, or if they have capacity to contract at all, it is only under strict circumstances. And what are those? We have like the minors, also known as infants, right? Then we have those who suffer from mental problem, mentally deranged persons or lunatics. And then you have those who have lost their sobriety, who are not sober because they've chosen to drink plenty alcohol or something like that. And of course, we also have like the artificial entities, that is the corporations or companies. So with respect to minors or infants, last year there was a question about that. With respect to minors or infants, we have to remember that although there's a debate as to what the age is, but talking to your examiners, when I did interview of them, the impression I get is that because we have conflicting positions as whether the age is 21 or 18. If you stated 18 and you mention the, what do you call it, the age, right? If you mention 18 and, for example, sorry, mention the Children Act, that will be accepted. On the other hand, if you mention 21 and you stated that that is like the common law position, and in Ghana, if you take even like the Contract Act, there is no indication of the contractual age, that will also be accepted. So for now, if you look at subsequent enactments, right, we, please, those who hands are up, I've seen you, but as I told you, what I am doing this afternoon, I want to finish what I want to tell you before I take questions. So just put the questions down, okay? All right, thank you. Yeah, so if you take new enactments, if you tell maybe like the Companies Act 2019, you take the Land Act 2020 and all that, you get a clear impression that the lawmaker has actually endorsed 18. But for purposes of general contracting, although if you take the interpretation that it's only about 18, there's still room for debate. So if you said 18, you mark correct. If you said 21, you'll be marked correct, all right? Okay, so let's keep that in mind. So when it comes to infants, we have what they call the valid contracts, what they can enter into. A valid contract in the sense that when they enter into it, it is binding. But even then, the law still protects them because they don't have to pay full contractual price. They have to pay what they call like the reasonable price. An example of valid contract infants can enter into, they're talking about contract for necessaries, right? Contract for necessaries. And you know that necessaries are those goods which are considered suitable to the condition in life of the infant at the time that they are supplied. If you look at the Sale of Goods Act, I think the section 2 is defined over there. But even then, as I said, even where you establish that they are necessary goods, as in the case of Nash and Iman, the position of the law is that they must pay reasonable price and not the originally agreed price. So reasonable price will probably be like the actual cost of the item minus any margin of profit which the seller or the vendor might have put on it. Then we also have voidable contract. No, I mean, just before I go on, apart from contract for necessary, which is another example of valid contract, we also have a contract for beneficial services, right? Contracts which are meant to enable the minor to acquire a skill that may help him or her later on in life. All those things are valid, except that it must not contain harsh and onerous terms, as we see in the case of Di Francisco and Barnum. Di Francisco and Barnum, remember that the terms were really harsh and onerous. And for that matter, despite the fact that it was about vocation, about the helping apprenticeship, the court did not hesitate to strike it down as not being valid because the terms were so harsh and burdensome. So if it had not been for the harsh and the burdensome terms, it will have been upheld as a valid contract. Then we also have a voidable contract. Voidable contracts are those contracts which are considered binding for the time being, but can be repudiated or set aside by the minor, right? And usually upon attaining the age of majority, within a reasonable time of attaining the age of majority. So when it comes maybe like contract for the minor to acquire like a permanent interest, maybe like the land or conveyance and so on, if when the minor attains majority, the minor has the legal right, the ability to actually set aside such a contract if he or she thinks that a contract, for example, is not in his best interest and all that. Then again, we have void contracts, contracts which are automatically considered as a nullity and do not create any rights or obligation. For example, when a contract enters into a loan, right? If a minor enters in contract to take a loan or even like some other forms like a trading contract, they are considered void. The only exception in Ghana, if you tell like the student loan scheme, the PNDC law on student loan, where an exception is created that if you are a minor, that if you take the loan, despite the fact that you may not be an adult, so long as you are beneficiary of the loan, you are presumed to be of a full age. So let's keep that in mind. Then we also have those who are lunatic or who suffer from insanity. Now, what happens is that you are pleading that as a defense in order to escape from the effect of the contract. So when you are saying that you should not be held liable for a particular contract, because at the time that it was made, it was not during the time that you were in the lucid interval, you were very sane and all that, then you will have the burden to show that you suffered from the effect of the insanity and all that. And the other party will have to also show that due to certain things, it was quite clear that you were not suffering from insanity, it was not present and all that. So that is how it works. So it is also like voidable, it's not void and it's not valid. Then the same thing applies to intoxication. If you are claiming that you're intoxicated, you have like the burden to show that you had lost your sobriety and the other party was very much in the know that you had lost your sobriety and yet took advantage of you to enter into that transaction and you were not really in charge of yourself and all that. So these are the things that we have to remember. And finally, with respect to artificial bodies, like the companies and all that, in the past, we used to have this strict requirement that if you have like the company, you must have like a constitution, and then under the English system, we talk about the Memorandum of Association, Articles of Association, and in Ghana, there's a regulation now, the constitution. And you are supposed to have what we call an object clause, a clause in it in which you state the nature of business that you want to do, and so on and so forth. So therefore, you were taken to have been constrained by what you have stated as being the things that you would like to do, and you could not actually go outside that. And if you went outside, there's something called like ultra-virus, that you've actually exceeded your legal capacity. And you see that in the case of the Asbury Railway against Ritchie and all that. But today, if you look at even like the Companies Act 2019 Act 992 ultra vires is not so much like a big deal, especially so if a company does not have to adopt a constitution. It's only relevant when the company has adopted the constitution and has actually provided for object clause and so on. So let's keep that in mind. So this will mark the end of discussion of the capacity. Then we will move on to talk about consideration. So consideration is a very important element of a contract, especially when we are talking about simple contract, also known as Parol contracts. And as I indicated, simple contract or Parol contract is a contract which does not have to be in writing, right? I'm not saying that it cannot be in writing. It is not mandatory for it to be in writing and does not have to have like the seal of the parties. Because if you have like the seal of the parties, then it's a contract by deed or it's a contract under seal. Now, being a simple contract, the general position of the law is that it is not enforceable unless consideration has been provided. So question is, what is consideration? Before explaining consideration, just to remind you that the idea of consideration developed from what used to be called like the assumption, right, at common law. But consideration simply refers to the element of exchange in contracting, that the price which one is paying for a promise or what a person is giving in return for a promise, that is consideration. And if you look at it, consideration really serves the purposes of evidence. Evidence in the sense that since a simple contract or Parol contract does not have to be in writing necessarily, how can we be sure that I actually promise that which you are holding me to? If you can produce something, if you can show what you did in return for the promise that I gave or in response to the promise that I made to you, then that can actually provide a convincing evidence that I actually made that promise. Because if I have not made that promise, you wouldn't have done what you did in return. So that is the idea about consideration. But this is an area of the law we have to know that in Ghana, we have seen significant modifications, right? But for purposes of your examination, my suggestion is that you have to know the common law position, you have to know the modifications or the changes which have been made by our law, that is Act 25. And they are very straightforward. We'll get there very soon. But just before getting there, let me say that consideration may be executory or executed. Executory means that the act of consideration is yet to take place. It's futuristic, right? Executed consideration means that the act of consideration has already taken part, as it were. So let's keep that in mind. Past consideration means that the act of consideration took place before even a promise was made, and that is not right. We usually say that you must have a promise, and then in response to the promise, another promise is made. That is the consideration was provided. So a promise first before consideration, not consideration first before a promise. If what you are relying on as consideration happened before a promise was made, then that will make that consideration a past consideration. So let's keep that in mind. And before we move on, we also remember that the idea of consideration is against the background of the principle that the common law fronts upon what they call it nudum pactum. Nudum pactum simply means that a naked promise or bare promise. So that is the point for having consideration in simple Parol contract. Nudum pactum, naked promise or gratuitous promise is not binding or enforceable, because the common law, as far as simple Parol contract is concerned, is about a bargain, right? So there's no free lunch. That is why nudum pactum or gratuitous options are not enforceable. So let's keep that in mind. But of course, I made the point that past consideration as a general rule is not a good consideration. As you saw in the case of Lampley and Brighton, remember the guy who was the Ray McArdle, right? Remember Ray McArdle and all that. That past consideration is not like a good consideration. The only exception or some of the exceptions are maybe you have like a legislation which says that past consideration is a good consideration, like the Bill of Exchange Act. You give a check to someone or promissory note and so on. Now the check, the consideration for the check might have been some goods which was supplied or some services already rendered. So that is the consideration, but that has taken place before the promise represented by the check. But so that is antecedent liability. Now, if we look at the Bill of Exchange Act, antecedent liability is a legitimate or a good exception to the past consideration rule. And again, where the circumstances were such that the person who did something that which he has done, which is being called like the past consideration, for example, did it at the request of the one who has made the promise, as in the Lampley and Brightwood, the person who was facing murder charges and all that, and their penalty, asked someone to try and secure a pardon for him. The pardon was secured, and later on there was a promise to actually pay a reward. The court said that yes, because the person has done what he did at the request of the promisor, it will not just be treated as ordinary past consideration, which is not binding. So let's keep that in mind. And then having remembered that, we move on to sufficiency and adequacy of consideration. The general principle of law is that consideration must be sufficient, but need not be adequate. A consideration not being adequate simply means that the courts will not compare the economic value of the promises which A and B, for example, have given. If, like you saw in Thomas and Thomas, if you even take £1 to convey a whole house to someone, in absence of maybe any vitiating factor as like duress and so on and so forth, that will be it. And nobody will say that why such a transaction. Yeah, but that also means that it is not anything which the court will accept as a consideration. What to be accepted as consideration might be something of value in the eyes of the law, something of monetary value or money equivalent, and not any other thing which cannot be quantified, as it were. And for that matter, at common law, we say that if you have a contractual obligation and you perform that, you cannot rely on that as a consideration to support enforcement of a fresh promise. We saw that in the case of Stilk and Marek, isn't it? The seamen, when some left, and the remaining seamen were promised that work hard. When the ship should finish its voyage, we give you extra wages. The wages were not paid. And the court said that the promise to pay the extra wages was not binding because already they had a contractual obligation to do what they did. But in related case, the court said that where they have done more than what the contract required of them, then they will be entitled to the extra payment promise, as we saw in Hadley and Basindale. And then in more recent time, the case of Williams against the Ruffy brothers, that where you have done obligation you have under existing contract, but if it can be shown that it confers some extra benefit, right, or you suffer some extra detriment as a result of that, then you can benefit from the additional payment which has been promised by the promisor, as it were, despite the fact that you already had an obligation under the old contract. So let's keep that in mind. But if we look at Ghanaian law, the position is quite clear that if you have a legal duty, and the legal duty could be contractual obligation, or it could be a duty you have under law, right, to do something. If you have done that, Ghanaian law is saying that it can be a good consideration. It can be sufficient word consideration, meaning that the principle in Stilk and Marek does not matter as far as Ghanaian law is what is concerned. And remember section 9. Section 9 is quite clear that if you perform an act or promise, which you are supposed to do already under a contract or a law, that is sufficient word consideration. Again, at common law, you remember that if you perform a duty imposed on you by law, as in the case of a Collins and Godfrey, the person who was subpoenaed to come and testify, and he said that, well, I will not go, and the person who sued to benefit from the testimony promised him money, and he went. Later on, when he did not pay and he sued, he made the promisor made the argument that yes, if you are subpoenaed, right, you are summoned by the court, you have no choice. If you don't go, trouble for you. So what you did was something already enjoined by law. So you've not provided fresh consideration, and you are not entitled to this payment. The court agreed. The court only came to recognize an exception in Glasgow Brothers against the Glamorgan County Council, and in the case of the Harris against the Sheffield United, and so many cases in that direction, that where you have done more than what the law requires of you, then the extra performance, right, doing more than what the law requires, could be considered as sufficient consideration for the enforcement of the promise made, or the additional payment promise, as the case may be. But as I said, again, section 9 has made Collins and Godfrey unnecessary, because section 9 is taking care of Collins and Godfrey and Stilk and Marek, that where you've done something which is enjoined by law or enjoyed by contract, it is still sufficient consideration. All right, so let's keep that in mind. And then this will also take us to the so-called part payment problem, or variation of existing contract, so to speak, part payments. If you're owing, remember the rule in the Penal's case, as confirmed in the case of like the Folks and Beer, that if you owe someone an amount of money, and then the creditor has promised to accept a lesser payment in full satisfaction of the original debt, such a promise is not binding unless it is supported by fresh consideration. Or simply put, where a promisor has promised to vary the original terms of the contract, that promise is not binding unless you have provided fresh consideration. The same way of putting the rule in the Penal's case of Folks and Beer. So that was the position at the common law. And we all know the Penal's case, Folks and Beer. So I'm not going to belabor the point. We have a very limited time. But you see how later on, the common law, the common law courts recognizing the hardship, right? The hardship inherent in the rule in the Penal's case of Folks and Beer, evolved some solution in the shape of the doctrine of promissory estoppel, right? The doctrine of promissory estoppel was developed in order to mitigate the rigor of the common law as far as the rule in the Penal's case of Folks and Beer is concerned, as it were. So what was that solution? Remember very well that in the old case of Hughes against Metropolitan Railway, as far back as 1877, the House of Lords actually laid foundation for what will become promissory estoppel through the the crusading effort of Denning J, as it then was later in the high trees case, central lending property against the high trees. Remember that. And promissory estoppel simply says that where a person who has a certain legal right, has promised the other person against whom he can exercise those legal rights that he is not going to insist on his straight legal right. And if the other party against whom you could have exercised the legal right, for example, believe and rely upon that promise so made that he's not going to insist on his straight legal right, then later on, the one that is the promissor, the representor, who had the straight legal right and I created the impression that you're suspending it, will not be allowed to rescind, right? To go back and do what he said he will not do, and so on and so forth. But promissory estoppel, we have seen, is a shield, but not a sword, meaning that it is just a defense. You cannot use it as a cause of what action. That seems to be like the trend of some of the, although in more modern times, there are some one or two cases coming up who says that you can mount a cause of action on that, but I don't want to get into that debate. And I don't think it's important for your examination. It's more for advanced law of obligation. So let's leave that for now. And there's a requirement for reliance. The other party must rely upon the promise that you made, that you're suspending your legal right or you're not going to enforce it, and so on. You know the facts of the high trees case, so I'm not going to belabor that as it were. But in Ghana, promissory estoppel is very nice, but it's not so much a big deal in terms of being a solution to the problem in the penal case of food and beer or the power payment problem. Because if you look at our own law, right? If you look at section 8, subsection 2 of the Contract Act, it effectively detentions or it abolishes the rule in the penal case of food and beer. Because section 8.2 says that a promise to waive a debt and so on is binding, despite the fact that consideration has not been provided. And if that is so, what it means is that if Fox and Beer penal case happened in Ghana after 1960, following that 25, the conclusion will have been different. So let's keep that in mind. And that is why I said that if you are looking at promissory estoppel, it's being just a solution to the problem in the penal case or the Fox and Beer, then we in Ghana is not so much like a big deal, because already section 8.2 has taken care of that. Of course, if we look at the Evidence Act, I think section 22, thereabout, just about the estoppel by what? By conduct and order. I mean, that is fine, but with respect to promissory estoppel, high trees case, a good solution is rather section 8.2. So that is a very good solution to the penal case as far as Ghana is concerned. So this will mark end of our discussion of what they call like the consideration, and we will quickly move on to talk about terms of, we talked briefly about privity of contracts, and then okay, so we come to privity of contracts. I think I've discussed section 9 already. Okay, the section 9 is relevant to the situation in Shadwell and Shadwell. Shadwell and Shadwell actually propounded the position as to whether a third party, right, can provide consideration for a promise. Now, if you take Shadwell and Shadwell, what happened was that there was a relationship, and one had promised to marry another person, and Nickel And the uncle became happy of the promise by the nephew to marry the fiancée. So the uncle wrote that he'll be supporting them with money until the nephew and the new wife-to-be had actually made enough to be able to take care fully of themselves. So the marriage took place. Eventually, there was a default, and action was brought to enforce it against the uncle. And the question was whether consideration had been provided to the uncle's promise, because already having promised to marry the girlfriend, the fiancée, as at that time, just like in Ghana, of course, in England and Wales, following in the 70s, they have abolished a course of action called the breach of promise to marry. But here in Ghana, we haven't abolished it. It's still part of our laws. So having promised to marry the girlfriend, the nephew was under legal obligation, under contractual obligation. If he did not marry her, the girlfriend could have sued him, right? So by going ahead to marry her, fulfilling a contractual obligation that you owe, can you use that to be a consideration for a promise by a third party? Because like the uncle is a third party as far as the contract with the girlfriend is concerned, or the girlfriend is a third party as far as the contract between the nephew and the uncle is concerned. So if you have married, if you perform a contractual obligation to a third party, can it be a consideration to support a promise by the uncle? That was the crux of the matter. But if you come to section 9, it's to the effect that the performance of an act or the promise to perform an act may be a sufficient consideration for another promise, notwithstanding that the performance of that act may already be enjoined by some legal duty, whether enforceable by the other party or not. So whether enforceable by the other party or not, so it does not matter that, let's say that having regard to Shadwell and Shadwell, that the girlfriend could have sued the nephew if he had not married her and so on. Section 9 is saying that if you have performed a contractual duty owed to a third party, that can be a good consideration. That can be sufficient consideration. So let us keep that in mind. And I think, yeah, I think that should bring us to the end of discussion of the consideration. And as I indicated there, this is a very broad brush that is moving very fast on assumption that we've done the learning of it already. And what we are doing is just a brush up, okay? So if you have like questions, you can just note the question. Very soon, I'll be releasing you for you to contribute towards the discussion. The reason why I'm not allowing you to contribute now is that if I'm to do that, we will not finish what I want us to finish. And I don't want to come back to this again. Okay, so I was just going to talk about the privity of contract. By privity of contract, we originally, the understanding is that a contract does not create a right or obligation for third parties, right? If you're a stranger to a contract, stranger in the sense that you're not the one who provided the consideration, as was stated in the case of Twaddle and Atkinson. Remember, like the two fathers who promised that if a marriage took place between the son and the daughter, they're going to contribute money. And later on, the girl's father defaulted. So the husband wanted to enforce the contract against the father-in-law. And question was whether the son-in-law, that is the girl's husband, being a stranger to the contract between the two fathers, could actually enforce it. And the court said that no, because he had not provided consideration, it did not matter that he stood to benefit from that. He could still not enforce it. And later on, we see that the case of a Dunlop pneumatic star against the suffrage, the House of Lords making the point that a contract does not create a right or obligation for third parties unless you provided consideration. And at common law, there have been some exceptions, or there have been ways by which you can go around that. So we've mentioned that already in some of our previous sessions, that where you have a trust, the beneficiary can enforce the trust against the trustee, despite the fact that they are strangers to the contract between the trustee and the settlor, as the case may be. If you have like an assignment means that a person who is a party to a contract has transferred his right and obligation under the contract to a new person called the assignee. So the assignee can enforce the contract against the original other contracting party, as it were. Or if you take like the restrictive covenant, right? Restrictive covenant, we notice run with the land. So if there's a restrictive covenant that don't use the land for a particular thing, then despite the fact that it was made under original head list, it will run with the land so that all subsequent successors in title will be bound by that restrictive covenant, despite the fact that you're not party to the original head list or arrangement under which it was created, as it were. Then agency. Agency is another way by which you go around privity of contract, so that the principal functions through the instrumentality, right, of the agent. So contract between the agent and third parties, the principal can enforce it, or third parties can enforce it against the principal, as it were, especially so where the agent has disclosed to the third parties that he is not acting on his own, he's acting for someone. So let's keep those things in mind. And you take some legislation like the motor traffic third party ordinance. When it comes to the third party insurance, insurance is between the insured and the insurer, right? The car owner and then the insurance company. And yet, victims of accident caused by the car can actually sue to enforce the insurance contract between the insured and the insurance company. Now, more importantly, if you come to the Contract Act, section 5 of the Contract Act, that is like the game changer as far as our law is concerned. Hello? Hello? I'll call you back, okay? Okay. As far as our law is concerned, because section 5.1, as we know, is saying that where a benefit has been created for you under a contract, or where you fall within a class of designated beneficiaries under a contract, you can enforce the contract, despite the fact that you are not a party to the contract. And this is, if you like, a fatal blow to the rule in Voidable and Atkinson, Dunlop and pneumatic tie. Because Voidable and Atkinson, Dunlop and pneumatic tie, you see clearly that the contract was for benefit of someone, but the beneficiary could not be recognized as having capacity to enforce the contract because they were seen as not previous, they were seen as strangers. Section 5 is saying that if you are beneficial, if you have a benefit created and a contract for you, or belong to a class of people who have benefit created for them under the contract, you can enforce the contract despite the fact that you are a stranger. So let us keep that in mind. So that is important. Yeah, I think this will mark the end of discussion or revision of like the privity of contract, and we'll move on straight away to talk about terms of contracts. So we are gradually getting towards we are just at the middle of our revision. So I'm sure that in a few minutes we should finish. We are trying to do the impossible in the sense that things that we do over 8 months, we are using 2 hours or so to revise it. Okay, terms of contract, also known as content of a contract. This relates to the obligations, the duties and rights contained in the contract. A contract is not for fun, or it's not a joke. It creates obligation or duties for the parties, and it also creates rights. So the terms or the contents are what enable us to know what exactly the party have contracted about. So for this, we need to pay attention to certain things. We are going to quickly pay attention to how to recognize terms in the which the parties themselves have actually negotiated, and how to recognize terms which the party have not negotiated, what you call the implied terms. And then how do you classify terms? And then we also talk about what we call the exclusion clauses, and then we are done. So first and foremost, we have to remember that where the contract is reduced into writing, as we often say in our local language or a parlance, that book no lie, isn't it? Book no lie. Book no lie in the sense that if we are not clear about what is contained in the contract, we can just open it and then everything is there. So there's no problem. But where it is not necessarily reduced into writing, and we need to find out what the party have agreed upon, then we will need to actually employ what we call like the objective test. So all the discussion that we said concerning the objective test of agreement are important in trying to recognize what the parties agreed upon, especially so where the contract is not in writing. So where we have like it's Parol, right? It's Parol, it's not in writing, then we need to do that. And again, where the contract is not in writing, the other thing we have to remember is that various statements, right, might have been made at the time that the contract was made. What do you call like the pre-contractual statements which are made before the contract is concluded. Are they all meant to form part of the contract, or they don't form part of the contracts? Now, the ones which are meant to form part of the contract, we call them the terms, and the ones which are not meant to form part of the terms of the contract, we call them like the representation. So representation is a statement of fact meant to induce someone to enter into the contract. When it turns out to be untrue, it doesn't give you the right to sue for breach of contract. It only gives you the right to sue for misrepresentation, as the case may be. So let's keep that in mind. So in trying to find out whether a statement which was made at the pre-contractual, so that negotiation stage, is a term of contract, we have to find out the time in which, if it was made closer to the contract, then it is meant to form part of the terms of contract. But if it was made long before, then it is not meant to form part of the terms. These are just like the general presumption, but it doesn't mean that we cannot rebut them in appropriate circumstances. And again, we also find out how important the statement was. If the statement was really, really important, then we say that it's meant to form part of the terms of the contract, and vice versa. And then we also look at the expertise of the maker of the statement. If the statement was made by someone with reasonable expertise and all that, then the position of the law is that such a statement is meant to form part of the terms of the contract and so on. Now, just before we leave the terms that the parties have actually agreed, the express terms we are talking about, that's what the parties have themselves negotiated. Now, when it is in writing, as I told you that everything is in writing, Then all that we have to remember is what we call like the Parol evidence rule. Parol evidence rule simply means that no extrinsic evidence will be admissible to contradict, vary, or add to that which have been reduced into writing. Of course, we have exceptions. We have exception, that is where what is reduced into writing does not represent the entire contract, right? So what do you call like the entirety rule, where it is not obvious that what you have is representing everything. Then the court may want to take evidence outside the writing in order to establish what the true intentions of the parties are. Now, we also have to remember what we call the relative importance of terms, because not all terms are of the same importance. Some are more important than others. So traditionally, we had condition and warranty. A condition, as we remember, is the term of major importance in the sense that it goes to the very foundation of the contract. And what that means is that where there's a breach of it, it entitles the innocent party to treat the contract as having come to an end. And he or she can sue for damages, can sue for compensation. And again, if he is also sued, he can set up the breach as a defense to any request for specific performance by the other party. On the other hand, where a term is of relatively lesser importance, we say that it's a warranty. And what that means is that a breach of it does not entitle the innocent party to actually repudiate the contract, that is, treat the contract as having come to an end. But you have to actually continue the contract, except that you can sue to recover damages. Now, this brings us to the question, how do we know whether a term is a condition or a warranty? The courts have said that if you look at the schooler against the workman machine tools, that is not about the label which the parties are giving to the term, but the intention of the parties. So the intention of the parties is about examining what the parties have said, what they have done, and then we'll be able to determine, or what they've written, then we'll be able to determine whether this particular term is a condition or a warranty, and not they just say that this is a condition or this is a warranty, and that will be conclusive of the matter. No. Yes, the court actually give importance to what the parties intend, but what the parties intend should be decipherable from what they have expressed. Then finally, with respect to relative importance of term, we have to remember that in the last 50 years, thereabout, the courts have recognized what we call like the hybrid term, right, intermediate term, which lies between condition and a warranty. What they call innominate term or intermediate term. Remember the famous case of the Hong Kong Fair against the Kawakazan, Lord Diplock, where he said that certain terms are such that you cannot classify it as a condition or a warranty. And you need to actually wait for a breach to occur. When a breach has occurred, then you'll be in a position to actually determine whether we should give remedies, which are usually given for breach of a warranty to the innocent party, or we should give remedies which are given for breach of a condition to the innocent party. So for innominate terms, we simply say that it follows what we call like the wait and see approach, right? Wait and see in the sense that you wait for a breach to occur and then you gauge the effect of the breach on the contract before we can know whether to treat it as it were as a condition or as it were as a warranty. Now, we also have to remember implied terms. Implied terms are those terms which the parties, as we've said already, have not necessarily negotiated and agreed upon, but for some reasons, the law says that they should be considered as forming part of the contract. And there are three main ways in which terms which the parties have not necessarily negotiated and agreed upon may be inferred or may be read or implied in the contract. One, they may be implied by statute. For example, we have the Sale of Goods Act, which says that for a contract between a buyer and a seller, certain duties are taken as forming part, even where the party have not negotiated and so on. So that is there. And of course, when it comes to contract for sale of land, remember the Land Act, which has repealed the conveyancing decree as it were. Not only that, you take like the contract between an employee and employer, you take like the Labor Act. There are a lot of implied terms over there. Good. Terms may also be implied by custom. So by custom simply means that the court will look at the custom which exists either in a particular community or which exists in a particular trade or industry. Remember the Hattons case. Yeah, and finally, terms may be implied by the courts. When the terms imply courts, they are trying to, for example, achieve what we call business efficacy. In other words, trying to uphold the business purposes of the parties. The parties have made a contract for it, especially in the commercial setting. The parties have made a contract for it to work. So where the contract as made appears to be unworkable, right? And it is necessary for the court to imply, to read in additional terms so that the contract as made by the parties will be workable, so as not to defeat the business purpose, so as to make it business efficacious. Then terms may be implied. And again, the court may imply terms in order to fill in obvious gaps in the sense that, as the case of Liverpool against Owen points out, that when the parties were making the contract, if their attention had been drawn to the fact that something was missing, they would have said that, yes, of course, this is part of it. Yeah, so these are the ways in which terms may be implied. And finally, we want to talk about exclusion clause. Exclusion clause, as we have explained before, are those clauses in the contract by which one party seeks to either escape liability completely when it's in a breach, or to limit how far it can be held liable when it's in breach. And we've noted that that is frowned upon by the law because it suggests unfairness. How could you say that when I'm in breach, don't hold me liable, or when I'm in breach, my liability cannot go beyond that? On the face of it, it appears to be unfair. So the court is quite stringent and rigid concerning what must be done before same will be considered as valid. So we have discussed already extensively before that before exclusion clause will be valid, there must be evidence of incorporation, right? First one, evidence of incorporation. It must have been incorporated, that is, must form integral part of the contract. And secondly, when a breach has occurred, the wording or the scope of the exemption clause or the exclusion clause must actually cover the incident or the event of breach which has occurred. So these are the two mechanisms by which the court is to control exclusion or exemption clauses. And then we say that for how do we establish that it's been incorporated, that it forms integral part? We said first, where the exemption clause requires signature, the fact that you have signed is evidence of the fact that you have accepted for it to form part of the contract, right? So that is the general rule. And we've seen the Lestridge and Grabcop, and we said that if you don't read, you are still bound by it. Of course, the only exception being the illiterates, or you talk about the illiterate protection ordinance. And in the case of Zamrama and Zebedee, that if an illiterate, then there must be evidence that it was read and interpreted to him in the language that he or she understands before he or she can be held to the transaction, and so on and so forth. So let's keep that in mind. Then, of course, other thing is that where it requires signature, you have signed, but you sign in circumstances in which you do not intend to sign what you actually signed. Either you were deceived into signing it, or you signed it as a result of fraud, as in the Curtis chemical case. Or you are saying that what you sign is radically different from what you intended to sign. So you are playing what you call like the non-ex factum. Then you can be allowed to escape from the effect of your signature. So let's keep that in mind. Now, where the exemption clause does not require signature, we have seen that there must be notice, and the notice should be reasonable. There must be reasonable notice about the existence of the exemption clause. As to whether something is reasonable notice or not will depend upon the circumstances of the case. You've seen a number of case law illustrating that. You can go back to the earlier recording on the terms to get more details about it, just in case you need more assistance, so that we don't belabor that particular point. Now, finally, with respect to exemption clause, we have noted that where there has been a breach, right? Where there has been a breach of contract and someone wants to take advantage of the exemption clause, the exemption clause will need to be interpreted to find out whether it actually covers the fact of, or the incident or the event of breach which has occurred. Now, where it is interpreted and it is found out that there is ambiguity, right, in the exemption clause, meaning that it is capable of bearing more than one meaning. And let's say that one of the meaning is more advantageous and other is more disadvantageous to the person who is, at whose instance the exemption clause is included. Remember the contra proferentem rule. Then the law says that the court will construe it against the interest of the person at whose instance the exemption clause is included in the contract. And that is the essence of the contra proferentem rule. You have to remember the Horton and the Trafalgar case, and so on and so forth. Then we also talk about the doctrine of fundamental breach, which used to be the case in the past, that where there has been a fundamental breach of the contract, meaning that a term of major importance has been breached in a very severe way, that the entire contract is considered as having come to an end. Then what that means is that the exemption clause does not also work. It also comes to an end. Now, in the case of Securico, Securico, if you remember, against the photo production case, you know that the courts have said that we no longer have to abide by the fundamental breach doctrine. Rather, we have to adopt what we call the constructionist approach, meaning that we need to interpret the wording of the exemption clause to find out whether, having regard to particular circumstances which have occurred, the parties did not have intention that it should be applicable, or they intended that it should be applicable. So that is how the courts go about it. So these are the things that we'll be discussing as far as the exemption clause is concerned. And finally, this will bring us to vitiating factors. So vitiating factors, we are talking about those things which actually render the contract, they affect validity of the contract, right? They affect genuineness of the contract. So we have mistake, misrepresentation, duress, undue influence. So mistake, where we've talked about the fact that it's not mistake of law, we're talking about mistake of fact, where someone had a fundamental misapprehension regarding a particular fact, so that the person will not have entered into the contract but for that serious misunderstanding as far as that fact is concerned. Then the party is said to have been mistaken. We've also said that the mistake must have existed at the time that the contract was made and not after, right? You remember the amalgamated the property against the Walker and Sons case. And we have also noted that mistake at common law will render the contract void, right? And in some cases at the inequity, the mistake will render the contract voidable. So we talk about mutual mistake, we talk about common mistake, and then we talk about unilateral mistake. Mutual mistake simply means that both parties have made mistakes, but they have made different type of mistake. The parties are said to be at cross purposes, so they are not consensus addendum, as you will see in the case of Raffle against the Witchers, right? Where one person is thinking that the contract is about the ship, the goods in the ship coming in October. Another person thought that it's about the goods in the ship coming in what? In December. That the SPLS case and all that. Now, as far as that is concerned, the position of the law is that where we apply the objective test and we cannot arrive at any point of agreement between the parties, then the court conclude that there's no contract between them. On the other hand, where you apply the objective test and you can actually arrive at a point of agreement, then the court will actually uphold the particular contract as it will. Then the common mistake also means that both parties have made the same mistake, right? And the famous illustration, the case of Kutura and his time, when they made the contract to buy, the item which was being shipped in the corn, when at the time that they made the contract, due to deteriorating the climatic condition, the master of the ship had actually made themselves that item, then the item was no longer in existence. But unbeknown to the vendor and the purchaser, they thought that the item was still in existence. And the court said that both parties made the same mistake regarding existence of the subject matter, which was actually not in existence. Then we also talk about unilateral mistake. A unilateral mistake, oftentimes the most popular one has to do with identity of the other contracting party. And the position of the law is that you don't make mistake regarding the attributes of the person. The person is this, the person is that. That is not really what the law is about. It's about like the rare identity. And for that matter, contracts are usually put into two categories. We have what we call, contracts are put in two categories. We have what we call the contract absentis, and you have what they call the contract interpresentis. So contract absentis, the parties are not dealing face to face. They are away from each other, right? So that being the case, where one party, for example, presents himself as another and gets the other to enter into contract with him. Now that party called the rogue knows very well that he's not the one that the other contracting party intends to contract with. So that would be like the unilateral mistake, as it were. I'm just creating the scenario, and then I'll tell you about the real legal problem with respect to all unilateral mistake as to contracting party. Then the interpresentis is where, let's say we have like a shop. Somebody came there, he pick items, and then instead of paying by cash, you probably use a check, and you will try to introduce him as maybe someone and somebody famous that you can easily relate to. And you agree to let him part with the thing, thinking that he's really the one. So the position of the law is that you actually intended to contract with the one who appeared physically before you, and not what he said he is about. And it's not really about his attributes. So that what he's saying probably is about like misrepresentation, right? But it's not really mistake as to his identity, as it were. Now, whatever be the case, in terms of unilateral mistake as to the identity, the position of the law is that, as a general rule, intend to contract with whoever you contracted with. However, that is a rebuttable presumption, and the presumption can be rebutted if you can show that there was a particular person you wanted to contract with, and the rogue or the fraudster that you ended up contracting with knew very well that he was not the one that you intended to contract, you intended to contract with, then you will be allowed to actually escape from that contract, as it were. But the rare problem, as far as unilateral contracts, unilateral mistake as to the identity of that contracting party is that you take A, B, C. A intends to contract with C. He ends up contracting with B. And then B is usually like the fraudster who has interposed himself between A and C. So B ends up taking the goods from A on credit, and then he will go and sell to D. All along, A will be thinking that he's dealing with C. Now, later on, he makes attempt to present the check for encashment. Then he gets to know that he has been defrauded, by which time B has already disposed of the subject matter to D and probably disappear into oblivion. Later on, A will find the item in the possession of D, and he may want to bring an action in a tort of conversion against or some other cause of action against D, because as far as A is concerned, he has not transferred title to the item to D. So how is it that D has it in his possession? Now, usually, for the court to resolve that, the court will need to find out what was the status of the transaction between the original offeror, that is A, and B, the fraudster. Of course, A never intended to deal with the B, the fraudster. If the court finds out that at the time that B sold the item to D, right, the innocent third party, A had not become aware of the fraud, and for that matter, had not avoided the contract, because the contract between A and D and B is voidable. If A has not taken steps to rescind the contract to avoid it, then B will have succeeded in passing a good title to the innocent third party. That is a D. On the other hand, if A had become aware and had taken steps to set aside the contract and all that, then will not be able to, B will not be able to pass good contract to the innocent third party. Because what it means is that as at the time B was selling to the innocent third party, the title, which was voidable, which B had actually been set aside, had been avoided. And we know that the enamel that could not have it, isn't it? So that is how it works. So let's keep that in mind. Misrepresentation, I have discussed it extensively in my earlier recordings, and all that suffice for us to remember is that talking about misrepresentation, two things. We have to understand what it is, and then we have to know that the element of what? Inducements. So misrepresentation, as we have discussed already, is where someone has made a statement of fact intended to induce you, to persuade you to enter into the contract. You enter into the contract on basis of that statement of fact, and later on you get to know that that statement of fact which induced you to enter into the contract is actually not true. So that if it had not been for that statement of fact, probably you not have entered into the contract. So then you're a victim of misrepresentation. And it may be fraudulent misrepresentation, it may be negligent misrepresentation, it may be innocent misrepresentation. Fraudulent misrepresentation, you have to remember the word pick. You make statement which you know to be false, knowingly or reckless, as well that be true, and so on and so forth. So that is a fraudulent. And of course, the legal effect is that it makes the whole thing to vitiate the contract and so on. So go back to you can go back and play the other recordings that we did. For illegality, I'm not going to touch on it because we discussed it not too long ago. And then for discharge too, we discussed it not too long ago. Remedies, we've also discussed that not too long ago. So I'm going to allow you 15 minutes at the maximum to take questions and contribution before we end this session, so that we can take a break and wait for Sir Dennis at 5. So if you want to ask a question, just raise up your hand and then I'll allow you to speak. Okay, all right, thank you. If you raise up your hand, I'll allow you to speak. Otherwise, I will end the class and then we wait for Sir Dennis. I think I unlock the meeting. Let me unlock it now, okay? Okay, so if there are no questions, I haven't seen anybody hand up. What it means is that there's nothing to address. So I will end the class now. I prefer that you speak, okay? Because, yeah, I prefer, if you want to speak, just raise up your hand, I'll allow you to speak so that it's more, just raise up your hand, otherwise I'll assume that there's nothing to be discussed. And then we'll wait for the next class. Is anybody hand up? Okay, so let's do. Let's, yes.
Yes, sir. Quickly, someone is asking whether you are ending this session, we are ending this session or we'll continue to hold on until doctor comes.
So Dennis. Yeah, there's a different link for him.
Very well, thank you.
Okay, so thank you very much. And because of the yesterday, our alarm